Any adjournment request? Daily list for orders item 1.
May I please, Lordship? Lordship, I filed an interlocutory application. Some minor correction needs to be made in the substantial question of law, Lordship. Because Senved credit rules, it is not availed under exemption notifications. It is availed under Senved credit rules, Lordship. So that minor correction, if your Lordship allows me to make.
Yes, Mr. Lordship, I may be allowed to argue at the time of hearing. If Lordship thinks fit, that is required to be modified.
Argue at the time of
Hearing of the appeal lot
what?
on substance question of law, because earlier substance question of law.
They're simply saying this there is a this word Senved rules skip. Then check the question of law. What's the problem?
Okay, Lordship, I may be allowed to argue at the time of hearing. Because it is not yet
By changing this substantial question of law, altering this substantial question of law, your right of hearing is not going to be curtailed.
no, definitely.
While admitting this excise appeal, general excise appeal, this court has while admitting this central excise appeal on 4/10/2019, this court has framed the following question of law. Yes, 4/10/2019. Number while admitting a civil excise number so and so, civil excise appeal. Now an application is prepared on behalf of the
Appealant.
appellant with a prayer to alter or amend the question of law as framed by this court on 4/10/2019 in civil excise appeal number so and so. It is contended that as a matter of fact, the word Senved credit rules wherein the credit was availed has not been has inadvertently missing in the question of law earlier frame. Then it concept appearing for the revenue has no serious objection if the question of law as framed by this court in civil excise appeal number so and so on 4/10/2019 be amended to law. In such circumstances, the IA is allowed the question of law earlier framed by this court on 4/10/2019 in civil excise appeal, but is amended, and
There are 5, Lordship.
it may be treated that the following question of law is arising in this civil excise, in this central excise appeal. Para number 5 of the application is here. Exemption here open.
Exemption has been struck off, Lordship. That may not be required.
Yes.
Obliged, Lordship.
For admission item 2.
We grant this prayer, sir. ROB is constructed so the people may should not be allowed to cross the railway line, and you are asking that railway line
There is no other
alternate way should be provided.
there is no other my lord, service road provision also, my lord.
So service road, where is the question of service road?
Because
What you are, in fact, you are making this ROB so that the people may not cross the railway line. And you are
No.
saying you provide a service road for the purpose of crossing the railway line to the people, sir. Then what
No.
is the use of this ROB? Altogether.
Lordship, can you see the map as well as my lord?
So whatever it may be, the
Yes.
ROB is for this purpose only, that the people may not cross the line. That's why only the ROB is constructed. And in fact, as pointed out, in your representation, you said, "Okay, don't construct this ROB here."
We made some prayer before the authority to modify the, my lord, project.
Let it be, sir. The authorities have taken into consideration various factors, and thereafter they have availability of land, everything.
Our status, my lord, I have annexed, my lord, the status, my lord. But they have not yet, my lord, started any construction.
If they have not started,
Lord.
the question of changing
So-
that or modifying that route, sir. And what is the power of the court, sir?
Our representation, that may be,
The representation. you are
taken into
saying the
consider-
Representation, your representation is that don't construct this ROB even from here. That's also. Better you withdraw it and I will grant you liberty to
Lost.
raise that appropriate.
Lost.
So attempting to argue the matter for quite some time. When concept or inspection has submitted that he may be allowed to withdraw this PIL petition. However, the petitioners may be granted liberty to raise their grievance before the appropriate authority at appropriate level. Dismiss with liberty as fruitful.
obliged.
Item number 3.
Yes, sir.
Miller, in this case, my lord, as per terms and condition of 3 Miller, a self-attested copy has not been submitted at the time of submission of tender, Miller.
Your admission is there.
A private respondent.
No, private
And-
respondent, forget about private respondent.
Yes,
Your admission is.
Yes,
there.
my
You have
admission
not,
yes.
Submitted that. final-
soundness certificate has not
certificate.
submitted from the nationalized bank, Miller. That is the relaxation part. There is a relaxation part, Miller. Relaxation part is considered in favor of the private respondent, not in favor of the FLN.
That in fact, they have allowed this, this granted him the contract after verifying from the original.
Hmm.
The originals are there, only self-attestation was not there on that ground. It's a very technical thing.
As per condition, Miller, page 35.
It's okay, but it always relaxes. If original, whatever the certificates are there and they have verified it and thereafter they have granted, what's wrong? In fact, anyway, even though if we cancel this respondent, you're not going to get it. You're
Miller,
not going to get it.
Miller, then the matter may be fixed on Tuesday or Wednesday, Miller. My senior HRS will
Sir, but I think nothing, what the senior,
Miller.
your sole intention is that खाएंगे नहीं तो अगले को भी खाने नहीं देंगे उसका गिरा this is what your intention is, nothing else.
Tuesday, Miller.
Close for order.
Deeply obliged, my lord.
Obliged.
Item 4.
Lordship, the flyover is still under construction. And then Lordship, the work had started before the NIT was issued. And then there are two
Maybe-
NITs,
maybe for
Lordship.
that reason, maybe.
Two NITs were issued during the pendency of this matter, Lordship.
One in March 2023, another is June 2000.
Yes, Lordship.
So that's okay. So, what is your basic allegation?
My basic allegation is that it has violated the rules, Lordship. The rules say that without an NIT, they
But
cannot
now
start
the
the
NIT
work.
has been issued and the work has been awarded to the.
Lordship, now what will happen is that it will set a bad precedent, Lordship, because if they can do this, they can continue the work, then,
So,
Lordship,
so now what relief now you are asking?
Lordship, I'm asking for disciplinary action against the department, Lordship. And then, Lordship, because there are two NITs and we don't know on which NIT, on which DPR they're working, Lordship. A technical committee also has to be set up, Lordship.
The things, now if the work is for almost 40% work is complete.
Yes, Lordship. I'm not saying that the work should be, construction should be stopped.
Ultimately, the only result is to demoralizing the officer.
Yes, Lordship. But then if we don't do that, Lordship, this kind of problems can crop up again, Lordship. It is about the rule of law, Lordship. If they don't follow the rule of law in these kind of big cases,
Having heard the response of the party. We have the view matter requests consideration admit. For the hearings. In the month of September. Let us see जब तक काम पूरा हो जाए.
Item 5.
This is a lordship.
The district commissioner Kachar was supposed to file a
Report.
My lord, we have received the report, my lord. I'm just placing it before your lordship. We'll file an affidavit. My lord, it is apparent from the report that, yes, sericulture is in occupation of 60 bighas of land, my
You
lord.
have to vacate it.
My lord, no question, we'll do it, my lord. Let me bring this on affidavit, my lord. Since we'll be vacating also, my lord, subsequent to this affidavit. My lord, only thing remains is that, my lord, for the last 60 years, we have been protecting this place, my lord. We'll give it up, my lord. No issue. Only our another apprehension is that, my lord, this particular area, my lord, there is rampant, my lord, encroachment. There are private individuals, my lord, they also do it. Now, my lord, archaeology department, they should give an undertaking that they will, my lord, properly keep it intact. Because of us, my lord, last 60 years,
You have, in fact, the land is.
we have protected that land, my lord, because of the wisdom of
Do
the,
one thing, you do file an affidavit.
my lord.
That pursuant to this report, since we are in occupation of 60 bighas of this so and so land. So file an affidavit, we are ready to vacate it. By what time? Give us the time. And then
Fine.
we'll issue a direction to the archaeological to protect it by fencing it or by
Yes,
putting a
madam. Yes, madam.
boundary wall or something else.
Yes, madam. Because now we are more concerned for that. It should be protected. This land, it has to be protected
that we
properly, my
will
lord.
pass an order.
My lord.
Okay.
Deeply obliged, my lord.
Then it council appearing for the, you are appearing for
My lord, I will appear for all, my lord.
all,
My lord.
for all the respondents that submitted that. After the demarcation process has already been, a survey and demarcation process of the land in question is already carried out. And a report has also been, and he is also in, and he is in receipt of the report from the district commissioner. Kachar. Then it concept has submitted that he'll file the reports along with the requisite documents by filing an additional affidavit. He pays some time for the same time frame what is granted. When
My lord, just after Bihu,
just after the 3 weeks. One, 3, 5, and 6.
Easy.
Archaeological,
Oh, archaeology. Oh, RKD Chaudhary was here, my lord. So,
Archaeology.
Lordship, may I make a small submission, Lordship? Lordship, in the prayer, we also pray for the eviction of the individual illegal encroachers, Lordship.
so only we have asked him to vacate the 60 because of the land.
That is only for agricultural law, Lordship. For the individuals also like encroacher one
We'll
twenty.
pass an order on the next.
my lord will pass an order. Deputy Commissioner will ensure that it is vacated. my lord.
Employees, Lordship.
Item 6.
My lord, the basic question is, I have challenged the rule, my lord, and the prescribed qualification. So, my lord, that I'm not pressing that qualification, my lord. The rule, my lord, on the basis they have made an advertisement, my lord, the BTC, and that too, my lord, without the, my lord, adopting the rule, 2023 rules, my lord. So that has been under challenge, my lord. Learned him from the BTC, my lord. I have not seen him.
So if you are not challenging the validity of the rule, let the matter be adjudicated by the learned single.
No, I'm selling the rule, my lord. Only that prescribed, there is in rule 2 count, I have challenged, my lord. One is prescribed higher qualification, which was earlier a high secondary or metric, my lord. Now it's become a BSc with certain subject having 50% mark. That prescribing higher, that is under challenge, my lord. That is, my lord, I mean, not pressing. But I am just selling the rule that BTC without the following the paragraph 12 of the 6th rule, my lord, they have issued the advertisement on the basis of the rule 2023 without adopting.
Reply is already filed on B.
My lord, they have filed, but the reply is nowhere here and there, my lord. It may also take up with the another matter, my lord, 6/9/2025, my lord.
Here it after 4 weeks,
Well, maybe after immediate review vacation, my lord.
4 weeks.
Or it will let go along. My lord, maybe take up with this similar matter is pending, my lord. This is on different context, my lord. 6/9/3 of 2025, WPC number
That is on,
6/9/3,
same rule is enriched.
my lord.
List after 4 weeks along with so
6/9/3/2025.
fine.
Highly obliged, my lord.